Good day, viewers. Few weeks from now, some persons will be crying, while some persons will be rejoicing. In my previous video, I talked about judicial precedents, why Mr. Peter Obi will come out victorious in these ongoing court proceedings. And I said that 80% of Peter Obi's petition before the court are backed by judicial precedents. That is to say that the Supreme Court has already finalized and passed judgment in so many cases that Peter Obi has brought before the court. In this video, I'm going to give you the details from A to Z about this court proceedings update. But before we go into that, I want to let you know that the emergence of Mr. Peter Obi in Nigerian political space has saved Nigeria from a lot. You see that because of tensions in so many countries, military has taken over. But in Nigeria, we are still expecting that changes will come because we saw somebody who came into the space and gave us hope. And the hope is still alive. And that is what people are not seeing that Peter Obi has done for Nigeria. But that is not the purpose of this video. Let us go straight to the point about the details of this court proceedings that has been going on and why Mr. Peter Obi will become victorious very soon.
This is what Peter Obi and Labour Party submitted to the court on the following issues. Number one, Peter Obi and the Labour Party are asking the court to declare the presidential election results invalid. In their final address, Peter Obi and Labour Party proved that after they analyzed the data for the 18,088 polling units from where INEC uploaded unreadable results to the INEC results viewing portal, IREV, they found out that it represented 2,565,269 accredited voters whose results were mutilated by INEC. They established that 9,165,191 voters in those 18,088 polling units that INEC blurred their results collected their permanent voters cards, PVCs. Therefore, the number of accredited voters, that is 2,565,269,000, exceeded the margin of lead between Bola Tinubu and Peter Obi, as at the time INEC chairman Mahmood Yakubu declared Bola Tinubu winner of the election. Labour Party and Peter Obi concluded that INEC awarded the votes from those 18,088 polling units to Bola Tinubu and rendered the result sheet unreadable so that no one could see the votes received by other parties in those places. According to Labour Party and Peter Obi, there is no doubt that all the 2,565,269 accredited voters in those 18,088 polling units whose results were blurred by INEC did not vote for one candidate only. Therefore, Peter Obi and Labour Party prayed the court to hold that the final results INEC announced as at the outcome of the presidential election is invalid without, first of all, determining how many votes each of the candidates in that election received from those 2,565,269 accredited voters. Sadly, these are not the only votes INEC could not account for. According to Labour Party, INEC suppressed quite a number of votes in that election. Recall that Labour Party's witness made a data presentation to the court, which was not countered by any of the respondents. Again, remember that Labour Party's witness told the court that 39,546 polling units could not be accessed on the INEC results viewing portal, IREV. In these 39,546 polling units, a total number of 23,119,298 registered voters collected their PVCs and 5,532,553 voters were accredited on the election day to vote in those polling units. Therefore, when you add 5,532,553 accredited voters to the previous figure, which is 2,565,269 accredited voters, it amounts to 8,097,822 unaccounted votes, which is too high to be disregarded when you consider the margin between Bola Tinubu and Peter Obi as announced by INEC. The Labour Party's legal team clearly proved to the court that there was massive suppression of votes by INEC and that INEC ought not to have announced the election results without accounting for all the votes, particularly when the unaccounted votes are more than the margin between the candidates. INEC possibly believed that their refusal to give give Labour Party the hard copies that represented the blurred and inaccessible results will mean that Labour Party did not have sufficient evidence to prove their case before the court. According to Labour Party, if INEC witness claimed that they collated the results with hard copies and the blurred result sheet did not affect the outcome of the election, why did INEC not tender the hard copies in court? Also, why did INEC not certify the hard copies and deliver them to the Labour Party? Instead, they certified blurred IREV copies that are unreadable. Some of the things INEC uploaded to the IREV as election results include images of human beings, trees, and other funny things. Since INEC refused to tender the so-called hard copies in court, Labour Party and Peter Obi prayed the court to invoke presumption of Section 167, subsection D of the Evidence Act in their favor. Labour Party and Peter Obi also cited a Supreme Court judgment between Danladi and Dangiri 2015, where the Supreme Court held that an admitted document is incomplete. The party to be damnified is the one who ought to have produced the proper or correct and complete document if he failed to produce the said document in its correct form. Labour Party therefore prayed the court to refer to the 18088 blood copies as the results for the election. Again, on the issue of real-time publishing of polling units level results on IREF portal, this is what Peter Obi and Labour Party said in their final address. Peter Obi and Labour Party also told the court that the alleged technological glitch on the election day is not a valid justification for the outright violation of the Electoral Act, INEC regulation and guidelines and manual for election officials. The combination of these laws make the upload of forms EC8As to the IREV mandatory from the polling units immediately after voting is done. In their final address, INEC claimed that the Federal High Court gave them a judgment in the case between INEC versus Labour Party, which permitted them to conduct election and do collation of results anyhow they wished. The Labour Party, however, told the court that the said judgment INEC relied on is inferior to that of the Supreme Court on Oyetola versus INEC. Again, INEC in their final address argued that their guidelines and regulations are not binding, that they were mere ordinary instructions. Labour Party strongly countered that claim as inferior and baseless. They cited a superior judicial precedence by the Supreme Court in the case of Faleke versus INEC. In a lead judgment delivered by Honorable Justice Ogumbi, the Supreme Court held that the Manual for Election Officials 2015, which forms part of the 2023 version INEC is currently using, are not mere instructions or direction. Rather, they are subsidiary legislations which have the force of law. They have their origin from the Constitution and the Electoral Act. That is the law. And that is why you find citations of the Electoral Act in the INEC Manual for Election Officials 2023, 2015, and the rest. For instance, paragraph 2 of INEC guideline reads in part, electronic transmission and upload of election results and publishing to the INEC results viewing portal, IREV. One of the problems noticed in the electoral process is the irregularities that take place between the polling units after announcement of results and the point of result collation. Sometimes results are hijacked, exchanged, or even destroyed at the polling unit or on the way to the collation centers. It becomes necessary to apply technology to transmit data from the polling units such that the results are collated up to the point of result declaration. The real-time publishing of polling unit level results on IREF portal and transmission of results using the BVAS demonstrates INEC's commitment to transparency in results management. This commitment is backed by sections 47, subsection 2, section 60, subsection 1, 2, and 5, section 64, subsection 4A and 4B, and section 64, subsection 5 of the Electoral Act 2022, which confers INEC with the power to transmit election results electronically. The system minimizes human errors and delays in result collation and improves the accuracy, transparency, and credibility of the results collation process. Judging by this guideline itself, it is clear that INEC violated her own guidelines when it abandoned the real-time publishing of polling unit level results on IREV. And sadly, INEC officials did so intentionally because in their own words, they claimed that publishing of polling unit level results on IREV portal is not mandatory. In their final final address, Peter Obi's team of lawyers drew the attention of the court to Section 60 of the Nigerian Electoral Act 2022. This section makes the publishing of polling unit level results on IREF portal mandatory. It also invokes punishment for presiding officers who did not follow the law. Such erring presiding officers, if convicted, can be imprisoned or fined. Again, Peter Obi asked the court to invoke presumption based on Section 167, subsection D of the Evidence Act. Labour Party and Peter Obi reminded the court that according to their cybersecurity expert witness, it was negligence on the part of INEC not to have properly tested their IT infrastructure deployed for the conduct of the 2023 general election. The cybersecurity expert disclosed many vulnerabilities which established that INEC failed to comply with the standard and guidelines for government websites. Peter Obi and Labour Party therefore asked the court to invoke presumption based on Section 167, subsection D of the Evidence Act, since this evidence was not countered by the respondent and none of the respondents tendered any other test report on the contrary. Peter Obi and Labour Party also told the court that with all these strong evidence, they have established the non-compliance by INEC, and non-compliance was not only substantial but grievously affected the outcome of the 2023 presidential election held in Nigeria. They also asked the court to look at the evidence from data analysis by the mathematician witness that proves that Labour Party won Rivers and Benue states. The mathematicians computed the results from forms EC8As uploaded on the IREV, and they certified true copies of forms EC8As which INEC themselves gave to Labour Party. Since this evidence was not countered or challenged by all the respondents, Labour Party prayed the court to add 2 states, that is Rivers and Benue, to the number of states they won, while the APC will lose those 2 states. In view of these irregularities and non-compliance, Labour Party and Peter Obi asked the court to nullify the presidential election in the interest of justice and declare the purported return of Bola Tinubu invalid. You will observe that Labour Party carefully refused to claim that they won a flawed election, but they still presented the court with evidence that proves that they won. At this stage, the court can only decide which angle the pendulum of the judgment will swing. Again, on the statement INEC made before the election, whether it is binding or not versus the law of estoppel, INEC believes that they are not bound by the statement they made before the election. Recall that INEC claims and continues to claim that a federal high court gave them judgment that permitted them to conduct an election how they want, and so they think that they are at liberty, or they believe that they are at liberty to say that an election will be held in a specific manner before the election, and during the election they will now adopt a different approach from what they initially stated to the public. That is what INEC believes. INEC argued that there shouldn't be a consequence for that. However, the Labour Party and Peter Obi totally disagreed with the position of INEC and went on to ask the judge to determine whether INEC did not publicly represented and assured that it was irrevocably committed to complying with the law by adhering to real-time electronic transmission and publishing of polling unit level results on IREF portal. Is INEC not a stooge by reneging from this publicly given assurance? The Labour Party asked. The Labour Party posited that the law of estoppel is a substantive rule of law. They cited the Supreme Court judgment in the case of Access Bank versus NSITF 2022. The Supreme Court ruled thus: instructively, it is trite that plethora of cases reiterated the fundamental principles regarding estoppel. It was aptly posited by this court in Jacobs Oyeroba versus Ebowole 1998. Estoppel is now more than a rule of practice, and it can be rightly described as a substantive rule of law. A person ought not to be allowed to blow hot and cold, to affirm at one time and deny at another time. That is to say, to approbate and reprobate. The Labour Party and Peter therefore asked the court to hold that INEC cannot, after telling the whole world in Nigeria and in Chatham House in London that they will transmit and upload polling unit results real-time from the polling unit on election day, only to turn around and do the exact opposite and still think that they are within their rights to do so. Festus Okoye, INEC spokesperson, gave assurances in different fora, press releases, and interviews before the election that INEC will not abandon the upload of election results. Surprise Surprisingly, INEC's witness, who appeared in court under subpoena to tender the press statement that Festus Okoye released before the election, denied and told the court that the press release doesn't exist and that it is not in their records. It is unfortunate that a public institution like INEC, which is funded by taxpayers' money, will openly deny their own press statements. Regardless, the Labour Party downloaded the press release from the INEC website, provided the URL, and submitted it to the court during the hearing stage. The evidence was also admitted by the court. Additionally, the Labour Party referenced a recent Supreme Court decision in Oyetola vs Adeleke that supported the requirement for polling unit results to be uploaded mandatorily to the IREV. Regarding the threats made by Tinubu's counsel in their final address that the petitioners are encouraging anarchy by raising this issue of the INEC's failure to transmit results electronically, the Labour Party referred to them as a cheap, misguided, and obviously designed form of blackmail to attack the nation's constitutionalism and judicialism. It also aims at cannibalizing our democracy. Those are the words of Labour Party and Peter Obi. In their words, the Labour Party queried, when has it become offensive for petitioners to canvass a ground prescribed for the challenge of an election? Labour Party 1. Desperation taken too far can be extremely dangerous. Then, let's look at what Peter Obi said on the issue of 25% requirement in Abuja. On the issue of 25% requirement in Abuja, let's look at what Labour Party said against the argument, the blind argument that APC and Tinubu made before the court. The question to ask here is 25% of FCT votes required to win a presidential election? That's the big question here. Now, recall that Tinubu's lawyers initially argued against 25% mandatory requirement in Abuja, but ultimately considered that the word "and" is conjunctive. Reading their final address, it appears that they also accepted that 25% is required, but that it is 25% of the two-thirds of votes cast in Abuja, not 25% of the total votes cast in Abuja. These people, I wonder how they are reasoning. They claimed that there were 460,071 total valid votes cast in the FCT Abuja, and that 306,714 votes represented two-thirds of the votes cast in FCT Abuja. Tinubu's lawyers blindly argued that 76,678.5 votes represented 25% requirement in Abuja. According to them, INEC reported that Bola Tinubu received 90,902 votes, which is more than the 25% votes required to win Abuja. So they are just attempting to claim that Tinubu met the 25% criterion based on the election dispute between Awolowo and Shagari. For me, this is the worst mathematics ever. This is the worst calculation I've ever heard. The so-called learned people were smart by half, but certainly not smarter than the judges they are trying to mislead. After contending that Federal Capital Territory Abuja need to be treated as a state in their defense, they turned around in their final address and said that 25% of two-thirds of votes cast in the Federal Capital Territory Abuja is what is required. Who told them that one? They must have forgotten that a person ought not to be allowed to blow hot and cold, to affirm at one time and denied at another time. That is to say, to approbate and reprobate. To set the record straight, especially for the students of politics and for others who may have interest in Nigerian politics, what is required for a person to be declared president in Nigeria? This is what the law says. 25% of votes cast in Federal Capital Territory Abuja is what the law requires, not 25% of two-thirds of votes cast in FCT Abuja. No. Section 134, subsection 2B of the 1999 Constitution, as amended, is clear and unambiguous, direct and simple. To be declared presidential winner, a candidate must secure at least 1/4, that is 25% of votes cast in two-thirds of the entire 36 states of Nigeria. Also, the candidate must also secure not less than 25% of the votes cast in FCT Abuja. The literal interpretation of this section is that a candidate must secure 1/4, that is 25% of votes cast in 2/3 of the entire 36 states of Nigeria, and 1/4, that is 25% of votes cast in Federal Capital Territory, Abuja. This provision is so clear, direct, and unambiguous that you don't need a professor of constitutional law to comprehend. The use of the word "and" had been held by the Supreme Court to be conjunctive, which implies that the conditions in Section 134, subsection 2b are conjunctive and mandatory. It is based on the entire vote total, not just 2/3 of it. However, Peter Obi and Labour Party cited the following judicial precedents that forced the respondents to quickly concur that 25% votes is required to win FCT Abuja. Let's look at the Supreme Court judgments that affirmed 25% of FCT votes are required to win a presidential election. The Labour Party and Peter Obi's legal team referenced the Supreme Court ruling issued in 2022 in the case between FRN versus Ngajiwa, in which the Supreme Court decided that Abuja should be treated as a state, in contrast to Tinubu's lawyers who cited Section 299 of the Constitution, which states that Abuja shall be taken as a state. In that judgment, the Supreme Court held thus: the interpretation of the provisions of the Constitution, where the words of the Constitution are clear and unambiguous, a literal interpretation will be applied. Where there is ambiguity in a literal interpretation, a holistic interpretation will be resorted to. All sections must be read together and purposefully so that no section is rendered redundant and superfluous. If the words remain ambiguous, the intention of the makers of the Constitution must be discovered to determine the mischief sought to be cured. The court is entitled to consider how the law stood before the statute was passed, what the mischief was for which the old law did not provide, and the remedy which has been provided by the new law. Peter Obi's lawyers cited more legal precedents to back up their argument that the Constitution should be correctly interpreted. They highlighted prior court rulings that were exclusively based on the interpretation of Section 299, which stated that Abuja should be considered as a state. But they contended that in the issue of Abuja's 25%, the court must interpret Sections 299 and Section 134, subsection 2 together. They informed the court that in accordance with the 1999 Constitution, there is an extra condition for FCT. Therefore, the controversy over the presidential election between Awolowo and Shagari that the defendant stated does not apply in this instance. When interpreting Section 299 in its entirety, the authors imply that Abuja should be treated as a state for the purpose of exercising the executive, legislative, and judicial authorities granted to states. Because of this, the president serves as the FCT's governor. The National Assembly passes local laws there, and the FCT High Court has exclusive jurisdiction over the FCT Abuja. They used a 2015 court case, Iwuchukwu versus Attorney General of Anambra State, to back up their claim. Accordingly, the Labour Party legal team claimed that Section 299 will make redundant the wordings used by the Constitution's drafters in Section 134, subsection 2b, if it is interpreted individually, particularly where it reads, "and the Federal Capital Territory." Why didn't they just mention the 37 states of the Federation if Abuja is a state? The Labour Party asked. Furthermore, it is absurd that Abuja is absent from Section 3, subsection 1, which listed the 36 states of the Federation. They argued further before the court that the plain meaning of Section 134, subsection 2b, is that a candidate must win 25% of the votes cast in the FCT Abuja, and to 1/4, that is 25% of votes cast in 2/3 of the entire 36 states of Nigeria. The Supreme Court has determined that the word "and" is conjunctive, making it necessary. Additionally, "and" has received numerous judicial interpretations. For instance, Abubakar versus Yaradua, 2008. Regarding the use of the word "each" in the states of the Federation, they argued that it only applied to the individual specifically stated and not to others who were not included when a class was particularly mentioned. They cited the 2015 case between Grant Systems Petroleum Limited and Access Bank PLC as precedents to support their claim. They further informed the court that Section 299, which states that FCT should be recognized as a state, has no influence and bearing on this Section 134. The 1979 Constitution was silent on the 25% FCT requirement, but the drafters of the 1999 Constitution purposefully changed the section to include 25% of the total votes cast in FCT Abuja, partly because they wanted the winning candidate's popularity to extend to the Federal Capital Territory, Abuja, serving as the nation's capital and melting pot, that it will accurately represent Nigerians' wishes. The respondents' approach to interpreting the intent of the Constitution's framers as it relates to Section 134 subsection 3b is incorrect, and this section must be construed in conjunction with Section 14 of the Constitution, which says that sovereignty belongs to the people of Nigeria, from whom government, through this Constitution, derives all its powers and authority. Additionally, despite the fact that Section 2 of the Constitution indicates that Nigeria will be a federation made up of states and the Federal Capital Territory, no governorship elections were held in Abuja on March 18. Peter Obi and the Labour Party sought the court to dismiss the respondent's defense as lacking any value and ruled that the petitioner's submission is meritorious in order to grant them their reliefs.